Ma'am?
That's close enough, sir. Farina Sepulgal.
Sepulgal, excuse me, and Mr. Battaglia.
Good morning, Your Honor.
Okay, we are ready to proceed.
All right, thank you. Well, may it please the court, my name is Liliana Farina Sepulgal of Becker and Polyakov, together with my co-counsel Stephen Meser. We represent the Bayfront Tower Condominium Residential Association, Inc. In this case. This is an appeal from a final summary judgment entered by the Circuit Court in Pinellas County, and it arises out of a trial de novo the association filed after a non-binding arbitration before the Department of Business and Professional Regulations Division of Condominiums. While the briefs make it appear that this case is heavily fact-intensive, in our opinion, this is actually a pure question of law or questions of law that are before this court. What the association is requesting this court to do is that it reverse the final summary judgment entered by the trial court and direct it to vacate the final order entered by the arbitration. In a nutshell, what the association's position is in this case is that the trial court's final summary judgment has to be reversed because it is based almost entirely on a final order that was entered by the Department of Business and Professional Regulations, which I'll refer to for ease here as DBPR, in a matter where the DBPR did not have subject matter jurisdiction. As the court may be aware, the Florida statutes has a section for condominiums called the Florida Condominium Act, specifically Chapter 718. And in there is a section 718-1255, which governs disputes in condominiums. It specifically sets out the types of disputes that are to be heard by the arbitrator in the DBPR prior to it being further litigated in the courts if need be.
Ms. Farina Sepulgal, I appreciate your position on jurisdiction can be raised anytime, but what gnaws at me is the notion it's your client that invoked the arbitrator.
It invoked the arbitrator? No, sir, it did not. It was not the petitioner in the arbitration.
But you didn't object on any jurisdictional ground.
In fact, in the answer to the arbitration, there was a specific objection to subject matter jurisdiction, and that is at, I have the record site handy, I apologize, but in the answer to the arbitration, the attorney did specifically make an objection stating that the dispute that the petition had set forth was not one of the disputes that was set forth under the statute and should not go through arbitration, and that the petition should in fact be denied.
Okay.
However, your client did invoke the jurisdiction of the court by filing for trial de novo.
This is true. It did do so. It did so because in order to
And
stop
presumably, had you prevailed on the summary judgment, we wouldn't be having this argument from you.
This is true. This is true. Had the trial court denied and reversed, had it reversed the arbitrator's order, we would not be before you, at least not by our urging. Perhaps the appellees would have filed their own, but they had to file the trial de novo, otherwise the arbitrator's order would become enforceable. In fact, this is not a unique situation. In the Ruffins court, which we cite to this court in our briefs, the exact same situation happened where there was an arbitration followed by a trial de novo that was filed in order to stop the enforcement of the arbitrator's final order. And the appellate court in that case, sua sponte, noted the lack of the arbitrator's subject matter jurisdiction and indicated that despite the fact that it had gone through the trial de novo process and both parties in that matter till then had not raised the subject matter jurisdiction issue, despite that, the court found that it was appropriate to reverse the entry of the trial court summary judgment that had affirmed the trial de novo, the arbitrator's final order, and in fact directed the trial court to vacate the arbitrator's final order because of lack of subject matter jurisdiction.
If I appreciate the time and expense that went into doing the arbitration, but is your client any worse off because you basically had a second bite at the apple through the de novo trial opportunity?
Well, that's an interesting point, and I appreciate Your Honor raising that, because that's one of the problems that we found with the trial court's process. Let's say, for the sake of argument, a fact that we vehemently dispute. We don't believe that there is subject matter jurisdiction for the arbitrator to begin with. But let's just say that there was. Then what the trial court had to do was conduct a trial de novo. In fact, it should have received evidence. It should have heard itself the case. It didn't do that. All that it did was conduct an essential appeal of the, pardon me, I'm interrupting myself because I realized I didn't ask for time for rebuttal. I started in, and if I may at this point, I apologize if it's all right to reserve 5 minutes for rebuttal, and I'll get right back to your question. I'm sorry. The trial court didn't conduct a de novo review. In fact, what it did was it acted as this court sits in an appellate capacity with a closed universe record that was the arbitration record. That's not what a trial de novo was supposed to be. The trial de novo should have at least the trial court should have received its own evidence. The only
Counsel,
thing that it did.
in the trial de novo, your client moved for summary judgment. The Stars moved for summary judgment. Both sides agreed that there were no facts that were in dispute. And presumably had the ruling gone the other way in your favor, you would not be obviously raising the issue of subject matter jurisdiction. It's just that because the ruling went the wrong way, it just feels like the horse is out of the barn and we lost. And oh, by the way, circuit court, you didn't have jurisdiction to begin with, but you already agreed to let the circuit court make a decision based on competing summary judgment motions.
I can appreciate that position. I understand that that is what it appears to be. In fact, whether that is in fact the case or not, subject matter jurisdiction can't be waived. It can't be conferred by agreement, even if the parties, as the Ruffins case did, went all the way through the process. If the subject matter jurisdiction didn't exist, and the trial court's jurisdiction did exist to hear a case, but that's not what it did here. It entirely depended its review on the trial de novo process in section 718, 1255 of the Florida statutes, meaning that the entire process was conducted under a statute that didn't apply and never afforded the arbitrator subject matter jurisdiction. I can't cure what happened in the trial court. What I can raise to this court is that it is bound under Florida law to find matters that do not have subject matter jurisdiction to be without subject matter jurisdiction at any point in the process. There's ample law.
Let's assume that there was jurisdiction. And I guess what I'm focusing on is this nuisance that the Stars allege. Is it the result of more than just repair, replace, or maintenance of common areas? I have this vision of the association taking this exercise room back to the studs and just gutting it and starting afresh. And I'm not, in my mind, I'm not convinced that that's a repair, replacement, or maintenance.
Oh, I would agree with you. It is. We don't think that it is a repair, replacement, or maintenance. In fact, that is the reason why we don't find this to be subject to arbitration under 1255. That is exactly correct. This was something that was a complete renovation of the area. It did completely renovate, and including removing the existing flooring and implementing new flooring, which appears to have been what may have caused the issue between the parties. But had the appellees argued in the DBPR that the association didn't have the authority to conduct these changes, to have made these alterations, to have taken it down to the stud, if the authority of the board of directors had been challenged, that would have been something that the arbitrator was primed to do. That is the purpose of the arbitration proceedings, is to test whether the board of directors had that authority. But the appellees concede that they had the authority to do that. The authority has never been challenged, expressly excluded from the items that should be before the DBPR as a dispute in arbitration are matters that are just damages relating to the maintenance of common elements. So in effect, you're right. It is not just a simple maintenance of the common elements. It was a complete alteration, which was done with authority. part of the things that were part of the defenses that were raised in the arbitration as in the trial court, because once the association is in it, it does have to defend itself, as you can imagine. So one of the arguments that was made was that all of the actions it did was within its business judgment. Part of the problem that the trial court's order creates for the association is that it requires the association to implement a particular flooring determined by one unit owner's expert. The association is run by a board of directors that's elected by the unit owners, so that it can make these kinds of decisions. For the trial court and the arbitrator to both expressly require that this is the only possible solution to any issue that could have arisen, it's just beyond what they could have done. Certainly it's beyond what the trial court should have done when it was reviewing this, or should have been reviewing this in a trial de novo. Again, assuming that there was subject matter jurisdiction.
But to what extent at the arbitration did your client argue for an alternative to what was given?
What other options were presented? Is that the question?
Yes, ma'am.
Well, from what I can tell in the record, what happened is the association made changes consistent with its obligation to try to ameliorate the situation. The appellees were not happy with the changes, and so they provided their version of changes that would be acceptable to them. But the fact that the parties don't agree doesn't mean that the appellee's way is the only way. I mean, there are changes that all condominium associations make that are not happy changes for all of the owners, but that doesn't give one owner the right to dictate what the entire association has to do.
But
In this
is
case-
there any dispute that the nuisance was not resolved?
Well, there is a dispute as between the association and the appellees, certainly, because the appellees state that it continues to be a problem.
Okay,
There's
and
no
the
expert
association takes
testimony
a-
other than that produced by the appellees, is that right?
I'm sorry, if you could
There
repeat
were
that?
no experts other than what the appellee retained.
There was no expert testimony in the arbitration other than from the appellee. That's correct. But there were efforts that were shown by the association consistent to what other advice had been given. I just don't believe that testimony was given to the arbitrator.
So what do you think should happen now? Should we set aside the circuit court ruling, set aside the arbitration, order the parties to go back to circuit court and skip the arbitration
Yes.
step? Is that what you want?
I think that what we need to do, what I want is for exactly what you said. I would like for this court to direct the trial court to vacate the arbitrator's order, which was entered without jurisdiction. And if it is impossible for the parties to agree on a different alternative, one that is perhaps not as expensive or as changing as what the appellees suggest, which is a massive change to the flooring, and it would change the height of the flooring. It would cause all sorts of additional changes. That is not the only option. Are there other options available? I am sure that there are. I just think that being confined to the universe of what the associations, what the appellees have suggested is the only solution is improper. Not only from a subject matter jurisdiction standpoint, which the arbitrator had the issue with, but in addition to that, because the association has to have the freedom to make its own business judgments as to what is appropriate. The fact that the unit owners underneath the gym may find some noises coming from the gym, and that they have found one way to ameliorate that issue does not make it the only option for them. And the association has other unit owners to consider, including when it contemplates the cost of the renovations that will be required to implement the association's, the appellee's options, the actual modifications, the time that would be required to close the gym. There are other options available. And I don't think that it was appropriate from either the arbitrator standpoint, and certainly not from the trial court standpoint, to direct that only one option be used. In addition, and I don't want to beat the dead horse of the subject matter jurisdiction. I gather you have no further questions on that, and I think our position is clear. I think the statute is quite clear on the issues with subject matter jurisdiction. It certainly does not fall within what a dispute is under the statute. The plain language of the statute is there for all to read, and the arbitrator from the get-go, at the point that the association raised it, in the arbitration answer should have denied the petition for arbitration. This should have gone directly to circuit court. Different things may have happened. What happened in arbitration should not be what rules the rest of this case or the parties' relationship, particularly when it was wrong to begin with. But setting that aside for a moment, the other issue that we have here is summary judgment was entered here based on, again, complete reliance on what happened in the arbitration. This is improper. The trial court never had anything before it as actual competent evidence other than the affidavit of the association's president.
Ms.
The
Farina
appellees,
Sabagal, I want to interrupt you to let you know you're into your rebuttal time.
then
Use your time as you wish.
I'll keep the reservation of time. I appreciate the indulgence. Thank you.
Okay, thank you. Mr. Battaglia, you're up.
Your Honors, if it pleases the court, my name is Brian Battaglia, and along with Victoria McLaughlin, we represent the appellees Marlene and Ted Starr. Since 2014, the Starrs have been owners of a condominium unit on the 27th floor at Bayfront Tower located in St. Petersburg, Florida. Immediately above the Starrs unit is the fitness center. The association undertook a renovation to the building that also included in late 2015 and 16 alterations and additions to the existing fitness center. In approximately August of 2016, while those alterations and additions were ongoing, a disagreement arose between the Starrs and the association concerning those alterations and additions to the fitness center, a common element and area which resulted in severe sound and acoustical problems that emanated from the fitness center. Between August of 2016 through May of 2018, the Starrs and the association attempted to resolve the disagreement from their dispute by evaluating possible additions or alterations to the fitness center to solve the problem. The record reflects that the association retained an expert, then dismissed that expert, and then the president of the association, representing the board, requested that the Starrs have their acoustical consultants evaluate the fitness center and propose a solution. This was completed and presented to the president and board and the association pursuant to the legislature's directive under 718-1255 subsection 4, which is an alternative dispute resolution mechanism. That's what the statute says at the very beginning. That's the title of it. This was presented to them through that process. The Starrs then provided written notice of the dispute, a request for relief, and an opportunity for the association and board to comply or provide the relief as required by this dispute resolution statute. So they went step by step through this statute, which was implemented by the Florida legislature in 1991. When that did not occur and the disagreement continued, the Starrs signed and filed their petition for non-binding arbitration with the DP or DBPR, Division of Condominiums, under section 718-1255-1A, which sought solely equitable relief.
Let me interrupt you, Mr. Battaglia. Let's get to the nub. What is the portion of the statute that you maintain would give the arbitrator the ability to deal with this?
Sure. When we submitted the petition for arbitration pursuant to the statute, the section that is applicable in this particular instance is 718-1255-1A2. And what it says in the statute, a plain reading of the statute, it says that any disagreement between two or more parties, in this instance, the Starrs and the association, that relates to the authority of the board of directors under this chapter or the association documents to alter or add to the common area or element. And there was a disagreement relating to what had occurred as it related to that alteration, in addition to the fitness center, which was an existing common element for the use and benefit of the residents, including the Starrs.
But
So that was
you preface that by saying the authority of the association. Is there a question as to whether the association had the authority to undertake the renovation?
They had the authority, but the issue related to what occurred as a result of carrying that authority out. They did not have the authority to alter and add to a common element that resulted in a severe and significant acoustical issue. And in the statute, plain reading of it specifically indicates it relates to any disagreement. And that's what the arbitrator found. That's what the court found. It's
So-
not limited in some fashion to some argument that's being made by the association.
So
So
I
the
have,
stat,
the association has the authority to renovate the gym.
correct.
And your position is if they negligently renovate the gym, that is what gives the arbitrator the authority over the dispute.
Well, the arbitrator, yes, had authority in light of the fact that during this alteration and addition, which was ongoing, the association, which had implemented that, what resulted from that particular alteration and addition was this serious and significant acoustical problem. And that was where the disagreement began between the parties. And that's
Well,
what
let
the
me ask you
statute.
this, would it be a fair reading, the association has the authority? Could not one read it to say, well, the authority, the association can or cannot renovate? That's a question, but you seem to be adding more on. Once it undertakes the renovation, if it does it wrong, that creates an arbitrable dispute.
In this particular instance, yes, because again, the dispute was over the authority to alter or add to the common elements. And they did not in any way have the ability in what happened in this instance to create this particular significant acoustical problem. And in fact, because of the way the statute is created by the legislature, it's intended to be a dispute resolution mechanism. The jurisdiction or dispute mechanism and how it's defined in the statute is broad. It's not limited as suggested by the association. And what happened? Exactly what the legislature intended. The parties came together as a result of the disagreement. They had initially an individual who evaluated the flooring. They dismissed that individual. And then the association said to the stars, have your consultants prepare an acoustical report that tells us how to solve the problem. That's what we did. And they were actually there when we were doing it. And so that was submitted through pursuant to the statute, the notice provisions, which we were all working under, submitted it to them. Their disagreement and the dispute was not resolved at that point in time, although they were given reasonable time to do it, which is required by the statute. And then what happened is that, again, pursuant to the statute, we filed the petition. And the petition specifically stated at Appendix 38, 2378 and 2453, what the dispute related to. And it concerned Section 1A2. And then with regard to what transpired is that again, pursuant to the provisions of the legislative intent and the structure of this ADR mechanism, the petition with the allegations set forth therein as it related to the dispute, which was appropriate for them to review, was submitted to the Department of Business and Professional Regulation. This statute has been in effect for 30 years. They reviewed it as required by the statute. They, at that point, determined that this was a dispute and a disagreement under the terms of this statute. And at that point, arbitrator was assigned and eventually an evidentiary hearing was conducted over 2 days. And I would like to point out that at that hearing for 2 days, there was no issue about whether this was a dispute or not, or there was jurisdiction. It never was raised in a motion that was filed by the association. And so the decision was entered. The arbitrator found specifically that there was a dispute and outlined in a very comprehensive decision the ultimate conclusions and findings. And at that point in time, the association appealed that or filed a complaint actually in the circuit court, which again is pursuant to the statute. Now, with regard to the process itself, the association indicates that, well, as it relates to summary on the point of jurisdiction and whether there was a dispute and we met the conditions preceding, I would suggest to this court a plain reading of that statute. We did. It's not limited. It's expansive in terms of any disagreement. But with regard to the actual trial in the circuit court, the trial was the summary judgment. The parties when they filed the complaint for declaratory judgment, the association, the court entered an order. The court in the lower proceeding, the circuit court directed the association to bring up the record into the circuit court by order. And they did that. They attached it to their amended complaint. They attached the order, which was the arbitrator's order, which is evidence under the statute. And they also were directed to attach the complete record, which was the transcripts of those proceedings, which they did. What happened next is that we filed our amended answer to the amended declaratory judgment complaint that the association filed. In paragraph 1 of that particular answer, we admitted to the record that the court brought into the circuit court, the record from the arbitration. And those are at our appendix tab 9, 8, and 7, the actual order from the court directing the record be brought into the case. The association's amended complaint at the first page identified the complete record and the order. And then our answer admitted to that. And I'd like to point out a couple of things as it relates to that issue. That particular matter is raised in our petition or in our briefs and in the association's briefs. But what's important to note is that with regard to this court's previous precedent, in that particular process, it was a summary judgment, and that was a trial de novo. The parties agreed there were no disputed issues of ultimate fact. And under the Kahn case, because that was a trial, they did not meet their burden of persuasion. And what transpired was that the record is what the court reviewed. And in the Bryson case, which is a second DCA case, Bryson versus BB&T, 75 Southern 2nd, 783, in that particular case, the court noted that you can admit matters by pleadings. They're asserting that the record had to be certified, and that because of that not being actually certified, that it was not sufficient evidence. But the court brought it into the case. It was a matter related to what was being litigated before the circuit court, and we admitted to the record. So in Bryson, the second district said, well, you can admit to that in your pleadings. That's sufficient for summary judgment purposes. And that's what happened here. I think that's an important point for this court to consider. And then the other issue is in the Scott versus NCNB bank case, which was 489 Southern 2nd, 221 second DCA, the court said that as with other evidentiary matters, where there is no objection, it's within the sound discretion of the court. And there was no motion filed objecting to any of this admitted evidence. So it was proper, and the court properly considered it within its sound discretion. And there was no objection in the record whatsoever. And in fact, they filed a motion for summary judgment, as the court has noted, and counsel even said the testimony is what it is. They did not present any expert testimony. The only expert testimony was that from the stars. And so there were no disputed issues of material fact. The stars did everything that was required as it related to this ADR statute, this condition preceding to go to circuit court from the very beginning until the end. And that's what the intentions of the legislature were. I mean, as I pointed out, this statute went into effect in 1991, this ADR mechanism. And so that's what we followed. And I want to point out one thing. They cited to the Ruffin case. And in that case, they rely on that to say, well, because the arbitrator entered an order directing the son, who was not an owner, to do something, therefore there's no jurisdiction in this case. But in Ruffin, the court clearly indicated that, in fact, if it was the owner, which is in the statute, they did have jurisdiction. And in this case, a plain reading of the statute clearly indicates that this particular matter related to a disagreement. And the statute says any disagreement as it relates to what transpired here. The issues relating to the alteration and addition to the common elements. And there was a dispute concerning that. And the record is very clear about that. And if you look at what transpired, the parties followed what the intentions of the legislature were. They wanted these types of matters to be heard initially before the arbitrators and the DBPR. And then if it's not resolved, either because the parties can't accept the arbitrator's decision, then the next step under the statute is they file the complaint. And the trial was the summary judgment motion before Judge Covert in the circuit court. So, Your Honors, if I may, in conclusion, I would suggest to this court, based on the statute, based on this record, based on the findings, that there was a dispute within this particular statute that was determined to be a dispute by the arbitrator, by the DPBR, by the circuit court. I would request that this court so find, and also I would request respectfully that this court affirm the summary judgment motion and order that was entered by the circuit court judge out of the 6th Judicial Circuit of Florida, granting summary judgment in favor of the appellees, in this case, Marlene Starr and Ted Starr. Thank you, Your Honors.
Thank you, Mr. Battaglia. Ms. Farina Sabogal, 5 minutes. You're muted.
A sign of our times, right? You're on mute. My apologies. So first, I'd like to direct the court to the location in the record where it was first raised by the association in the answer to the arbitration petition, the lack of subject matter jurisdiction, and that's at record location 2470. At that location, the court will find part of the answer to the petition for arbitration, wherein the association specifically states that the statute does not include disputes for claims for damages to a unit based on the alleged failure of the association to maintain the common elements. Here, in contradiction with Florida law, the dispute petitioners are improperly requesting is an arbitration related to the alleged failure by the respondent to maintain the common elements of the fitness center. Since maintenance of a common element is clearly not a dispute pursuant to Florida statute, section 718, 1255, petitioner's request for arbitration must be denied. So this was raised in the first response by the association in the arbitration.
Where I'm having a little trouble is you call this maintenance.
I don't.
Okay.
I don't call this maintenance. I call this a renovation. And I think, in fact, Your Honor was right on point at the beginning of your questioning with Mr. Battaglia, which is what the statute dictates is, and it is not expansive. I disagree with Mr. Battaglia in that respect as well. The statute is express. It expressly states what is part of a dispute that should go before arbitration and what is not. It not only defines these kinds of disputes, but it also has a paragraph excluding certain types of disputes. This is not a free-for-all. Anything that has to do with condominiums needs to go to arbitration. It is a very specific statute. And as Your Honor noted, what the statute says is a dispute means any disagreement between two or more parties that involves the authority of the board of directors under this chapter or association documents to alter or add to a common element or a common area or element. The fact that the association didn't do changes, didn't make alterations or additions in the way that the unit owners wanted doesn't mean it didn't have the authority to do so. And the only thing that should have gone to the dispute under the DBPR arbitration and under this statute is a dispute regarding whether it had the authority to make these alterations. So I don't think it was maintenance. And in fact, that is our point precisely. Because it was a simple maintenance issue, it's the kind of thing that the arbitrators are not supposed to hear. The statute doesn't give them authority to do that. In fact, in the Ruffin case, which Mr. Battaglia raised as well as we did, he finds some comfort in the fact that that court said that if it was a dispute with a unit owner, then it should have gone before arbitration. Yes, that's true, had the rest of the case fallen within the dispute definition. The reason it was fine for the Ruffin case to have been heard in arbitration had it involved the unit owner is because the court was reading the language of the statute, and it found in that particular case, it didn't constitute a dispute because it didn't include a unit owner. In our case, it doesn't constitute a dispute because it doesn't have to do with the authority of the board of directors to alter or add the common elements. What the Ruffin case was cited for, and the precise point I'm trying to make with this case, is that the courts have looked precisely at language of this statute and have said, these things go to arbitration, these things do not. And I know, Judge Black, that you were frustrated with having gone through the entire process only to find ourselves here and have to start at square one. Trust me, we are as well. And I understand the judicial economy notions. I understand that this is a lot of time and expense. But the truth is that if subject matter jurisdiction didn't exist, it can't just be imposed as a matter of convenience. There's a reason we have these laws. There's a reason that there are limits. There's a reason that case after case in Florida has said subject matter jurisdiction can be raised at any time, even if for the first time on appeal. So I find that I find that there's no subject matter jurisdiction here and wasn't from the inception. I hope that you find the same. But beyond that, I also want to bring something up with respect to the record that the court invited to be filed before it. Had it been filed as a certified copy, had the court heard its own testimony, had a true trial de novo taken place before the trial court, perhaps we would be having a different conversation. I would still be raising the issue regarding subject matter jurisdiction because I don't think that that disappears. But I would also be able to abandon the issues that I have in this case, is that it is not based on any competent evidence. There was no actual evidence before this court that didn't come out of a procedure that wasn't with any, that didn't have any subject matter jurisdiction to begin with. So the entire case that the trial court is basing itself on was a proceeding that should never have happened. It didn't have
You're going to have
subject
to
matter
wrap it up, please.
In any event, I appreciate your time. We ask that this court reverse the trial court's final judgment and direct it to vacate the arbitration final order, as the court did in Ruffin, which is a 4th DCA case, but this case has also recognized in Winding Wood that there are disputes that belong in arbitration and that don't, and this is one of them that doesn't belong in arbitration, should never have been. Thank you for your time.
Thank you. Thank you both. Very well argued.
Thank
You
you.
can exit our virtual courtroom.
Thank you, Your Honor.
Have a wonderful day.
Thank you. And our next case is Swim and Sport